Great. Hi, everyone. Great to be here with you today. My name is Maria Callahan. I'm a staff attorney at Fair Housing Advocates of Northern California. Excited to talk more about fair housing law and the toolkit that fair housing advocates have. And I'm also going to turn it over quickly to Taylor just to introduce herself.
Yeah, hi, good afternoon, everyone. My name is Taylor Brewer, staff attorney here at the California Women's Law Center. What we do at the California Women's Law Center here, we're a support center, so we largely like to bring information to other attorneys regarding legal aid matters. Our capacity as a support center, we provide legal training, legal technical assistance, and advocacy support to other organizations on the issues we work on. So this is what this training is, and we're so happy to have Maria with us today to help share kind of her expertise here. And so I'll turn it back to her.
Great. Thanks, Taylor. And just a bit more about our organization, Fair Housing Advocates of Northern California. If you hear me use our acronym today, FANCY, FHANC, that's what I'm referring to. And our mission statement is to ensure equal housing opportunity and to educate the community on the value of diversity in our neighborhoods. Okay, so first we'll just do a really broad overview of fair housing law, not completely exhaustive, of course, and then I'll really turn it over to talk about investigating fair housing cases as well as bringing administrative complaints. So first, what is fair housing? Fair housing refers to the right to choose housing free from unlawful discrimination. So this is the ability for people of similar income levels to have available to them the same housing choices, regardless of personal characteristics such as race, national origin, gender, religion, disability, any protected class should not impede someone's housing choices. So an overview of the laws that we operate under with fair housing law. At the federal level, we have the Civil Rights Act of 1866, where the bulk of our fair housing protections come from. The Fair Housing Act, which was passed in 1968 in the wake of Dr. Martin Luther King Jr.'s assassination, and that prohibited discrimination on the basis of race, color, religion, national origin, and sex. And then the Fair Housing Amendments Act, which was passed 20 years later in 1988, which added protections based off familial status and disability. Then we also have Section 504 of the Rehabilitation Act, Title 2 and 3 of the Americans with Disabilities Act, and Section 109 of Housing and Community Development Act. So here's just an overview at the federal level, but then adding the state level protected classes. So I went over the federal laws. California has its own Fair Employment and Housing Act, which closely mirrors the federal law, but does add additional protected classes. So as you see federally, we do have race, color, religion, national origin, sex, familial status, and disability covered. And then California does add marital status. So whether someone is married or not cannot be discriminated against on either basis. Also age, ancestry, source of income, which includes any housing subsidy, a Section 8 voucher, someone's occupation, whether or not they work inside or outside of the home. Also genetic information, citizenship, immigration status, primary language, and arbitrary characteristics. And arbitrary characteristics is pretty broad. It really just means no one can be discriminated against based off any characteristic that wouldn't have an impact on their ability to be a good tenant. So a landlord can't say, we don't rent to anyone with tattoos. We don't rent to Capricorns, nothing like that. Nothing that doesn't, have an impact on your ability to be a good tenant. So what types of housing are covered by these laws? Fair housing laws cover all dwellings with some exceptions, and even the exceptions at the federal level are further narrowed in California. So really most dwellings are covered. A dwelling is considered anything occupied or designed as a residence, where someone has the intent to return. So you would probably automatically think of, renting out a single family home or an apartment in a multifamily apartment complex, but also mobile home parks, RV parks, condos, timeshares, nursing homes, shelters, group homes, and residential care facilities. So in this analysis, the intent to return is very important. So especially when you're looking at shelters, if this is the type of shelter where someone has a locker where they store their belongings or an assigned bed that, they'll leave during the day and come back and know that they're, coming back to that same shelter, that shelter would probably be covered under fair housing laws. But if it's, temporary, you stay there for one night, take all your belongings with you, and don't know if you have a bed guaranteed that next night, that shelter probably wouldn't be covered by fair housing law. And who is responsible in to uphold fair housing laws? So property owners, both individuals, smaller landlords, and corporations, property managers and management companies, and then pretty much anyone involved in the housing industry. So maintenance and administrative staff at properties, real estate agents and brokers, lenders, insurers, and appraisers are all responsible to comply with fair housing laws, as well as homeowners associations, architects, builders, and developers are, responsible for following design and construction rules, and municipalities and housing authorities are also responsible. So what activities are prohibited under fair housing laws? Prohibited activities are if, any of these activities are based off someone's membership in a protected class, they would be prohibited. So what you would probably most typically think of is refusal to rent, sell, or negotiate. So, if someone were to call and inquire about a one-bedroom apartment and it's a single mom with a kid, and the landlord says, "Oh, we don't want a kid in this unit. We don't think it's big enough." That refusal to rent would be based off her familial status. But there's a lot of other activities that are prohibited as well. So any discriminatory statements or advertisements that indicate a preference, limitation, or discrimination. False representations about availability. So if someone were to call and set up an appointment to view a property, and then when they arrive for the appointment, the landlord sees that they use a wheelchair. And then the landlord says, actually, the unit's already been rented. That, of course, would be a discriminatory act if the unit had not, in fact, been rented, and that was based off the person's disability. Also, steering, which can refer to oftentimes real estate agents steering prospective home buyers to or away from certain neighborhoods, but it can also occur in a single apartment complex or in a property if a property manager is showing all families with kids to the back of the property, and only adults are living at the front of the property, or people with disabilities are only shown ground floor apartments. Those would also be examples of steering. Blockbusting, which we, don't see so much anymore, but historically was a prohibited activity. And then also interference, intimidation, harassment, or retaliation for asserting a fair housing right. So if a tenant with a disability requests reasonable accommodation to have their emotional support animal live at the property, and then the landlord doesn't respond, but they give them a 30 days notice 2 weeks later, that would probably be considered retaliation for asserting a fair housing right. And that would also cover the next example, refusal to make reasonable accommodations or modifications for tenants whose disabilities make those necessary to use and enjoy their housing. So that was, oh, Taylor?
Yeah, sorry. So I just wanted to pop in. There is one question in the chat.
Great.
that asks, where do credit scores fall into these categories? I believe the categories being like protected classes.
Yeah.
Is it covered under fair housing if a landlord were to require certain credit scores to rent or inquire about this before granting tour or property of the property?
Yeah, great question. So landlords are allowed legally to impose certain credit requirements. It's just very important that those credit requirements be applied equally across the board. So, credit scores can't be used as a proxy to discriminate on a different basis. So, if a white applicant has a 650 credit score and a black applicant also has 650 and the black applicant is told you need 700 credit score to apply, that would be discriminatory. But as long as the credit score is applied equally across the board. But one thing to note, this is a new law, so I'm speaking, tentatively, but it's my understanding that law is going into effect where specifically for applicants with Section 8 vouchers or housing subsidies, if their credit score doesn't meet that requirement, a housing provider has to offer alternative ways for that applicant to show that they have the ability to pay their portion of the rent, even if, their credit score doesn't reflect that. But that's kind of on the horizon, so.
Yeah, great. And
Great.
then another question in the chat, given your example about refusing to rent to kids, what about evictions due to the unit being overcrowded and that an additional tenant, including a kid, is not permitted? How do you challenge an eviction in LA City due to overcrowding?
Yeah, another great question. So kind of similar to credit scores, housing providers are allowed to have occupancy guidelines, and there isn't a hard and fast rule, but in California, but generally, housing providers have to use a 2+1 guideline. So 2 people per bedroom plus 1 extra person for a living area. So saying you can only have 2 people in a 1-bedroom unit would be overly restrictive. You have to allow 3, but there's certain cases where you can also use a reasonableness standard, like if the living area were an abnormally large living room or something, the landlord would have to probably allow 4 people. And as long as I'm taking that question as if an additional minor has moved into the property since the tenancy started. I would say as long as, that additional person doesn't interfere with the occupancy guidelines and, any legal occupancy guidelines, then I would probably, argue that it's familial status discrimination.
Got it. Thank you.
Great. Those are great questions. I would love to dive in way more on all of those laws. So if anyone has more questions, feel free to reach out to me. But at this now, I'll move on to the testing and administrative complaints, but happy to answer more questions about the law as well. I think we're doing well on time. So if there's more questions, feel free to ask. So something that is a great tool that fair housing advocates have is testing. And a lot of people aren't familiar with testing, but if you have a case that you think testing might be useful, it's always great to reach out to a local fair housing organization and see what their capacity for testing is. I think most fair housing organizations in California do testing. So this is a great tool to have in your toolbox for any fair housing cases. So fair housing testing is an integral part of the enforcement of federal, state, and local fair housing laws. We really depend on testers to gather evidence of discrimination. As you can imagine from, most of the examples I talked about with the law, a lot of instances of discrimination would be hard to prove just based off, someone showing up to the property, being told actually the unit isn't available anymore. Without testing, we can't really prove, well, we always believe our clients, we can't prove one way or another whether discrimination happened. However, we use testers to, say in that example, someone set up their appointment with a housing provider, showed up, and they're using a wheelchair. and then they're told the unit is unavailable. We would have two testers each call the housing provider, one person whose test profile doesn't include a disability and one person whose test profile does include a disability. And the person without a disability would go ahead and schedule their appointment. Person with a disability, there's multiple ways to do it. In this example, we would probably just ask our tester to disclose during that call. Also, I use a wheelchair. Are there ramps on the property? And then get the housing provider's response. And that response is then used as evidence to either support the fair housing complaint, or, if both of those testers were told we don't have any units available, then we probably would see maybe it hadn't been discriminatory, what our client was talking about. Maybe the unit really had been rented. So this is just a great way to, figure out what's really going on here. Is it discriminatory? And then get evidence if it is. So kind of get ahead of myself, but testing can expose discriminatory patterns and practices of housing providers that might otherwise go undetected. Again, it's not always clear whether or not something's discriminatory just from the person's own experience. Testers can uncover differential treatment or policies with a disparate impact. So, of course, most of the examples we've used today are differential treatment, people just straight across the board being treated differently because of their membership in a protected class. But testing is also great at investigating policies with a disparate impact. So, for example, housing providers' use of criminal background checks. So, as we all know, due to Black and Latinx people's disproportionate arrest and incarceration rate in this country compared to their share of the population, any zero tolerance criminal background check policies have a disparate impact on Black and Latinx applicants. So testing housing providers to ask, what's your criminal background check policy? Is it zero tolerance? If you have, anything on your criminal record in the past 10 years, that probably has a disparate impact. And those are policies that if we just reach out to the housing provider as ourselves, as a fair housing organization, we probably aren't going to get the same information that a tester posing as an applicant would. So testers pose as interested applicants or home buyers and contact housing providers inquiring about housing availability and policies. They can investigate anyone in the housing industry, including property owners, management companies, lenders, appraisers, and others. So the, kind of classic testing that you think of is at the application stage for a rental. But fair housing organizations have done investigations really at every stage, testing lenders. So, having testers call and ask, pose that they are on maternity leave and they're looking to apply for mortgage. And, seeing how does the housing provider respond? Do they make any discriminatory statements about, whether someone on maternity leave is assumed to, not go back to work at a certain point, or, we aren't going to count your income on that application because you're on maternity leave right now. Appraisers, there are a few organizations in the country, maybe more than a few now at this point, that we have started testing appraisers. Appraisal discrimination, I know, is a hot button issue right now, especially. And how our organization has done it is we have had set up, multiple appraisals at one property, and we have either a white tester posing as a homeowner or a Black tester posing as the homeowner, and seeing, how are the houses valued differently, if at all, based off who's posing as the homeowner. So, testing goes far beyond just that classic rental application scenario. A little bit about the nuts and bolts of conducting a fair housing test. Testers are assigned profiles and are instructed to contact housing providers and then provide the Fair Housing Organization a detailed report about their experiences. So these profiles are very carefully crafted to, control specifically for whatever protected class we're looking to investigate. So testers will have similar income profiles. They're given, alias names that are with the goal of being racially identifiable if we're testing for race. They're given fake jobs and where they're currently living, just a real detailed profile of who they are as an applicant, and controlling for that, whichever factor we're testing about. The most common structure is match pair, which is what I've used in most of our examples. So that's just two testers calling with one characteristic being different, and then, being able to analyze how they're each treated after disclosing their protected characteristic. In California, of course, as we all know, I'm sure, we are a two-party consent state. So testers can't record the tests, unfortunately. And in other states, there is great evidence in their fair housing cases with recorded tests. But here, the results of a test are recorded in reports that are written by the testers following the test. So if it's a phone test, testers are taking great notes while they're on the phone. And if it's a site test, they're doing their best to maybe jot things down as a typical applicant would, without arousing suspicion. And then those notes are turned into a narrative immediately following the test. And they also fill out a report form. And together, the narrative and the report form become the evidence that we use to support our fair housing complaints. Audio and video recording is used in other states. So we're hopeful that someday in California, we might be able to record tests as well. But the documents, we do ask testers that we get those documents back within, a few hours of the test to make sure that everything is as true to the experience as possible. And we don't accept documents beyond 24 hours outside the test. So after we have those documents and we're able to debrief with our testers, we compare the test reports to determine whether there's evidence of discrimination. As you can imagine, this is not an exact science. A lot of times, investigations require follow-up testing to strengthen the evidence. Maybe, housing providers say we're testing for compliance with source of income laws, and a tester's asking about, does your property accept Section 8 vouchers? And the housing provider says, yeah, we accept Section 8, but you have to make 3 times the rent. Well, if that was the end of the test, we might then wonder with our tester, okay, do they mean an applicant has to make 3 times their portion of the rent, or are they still requiring someone with a voucher to make 3 times the contract rent, in which case, they wouldn't have a voucher in the first place. So they're effectively denying applicants with vouchers. We would need some follow-up on that. So the tester might call back and ask, I'm just trying to clarify, what did you mean by that? 3 times my portion of the rent. So it's important to have, that close relationship with testers. At Fancy, our testers are on-call employees. So, they all understand that a test isn't one call and done. It's an ongoing conversation until the test coordinators determine that the test is complete and we have our evidence. And the evidence is then used to support fair housing complaints or lawsuits. Just a little for the lawyers, a bit about the legality of testing. After covering what testing is, a lot of people might think, is this entrapment? Is this legal? Do housing providers know that this happens? And yes, federal law recognizes very clearly the legality of testing. Testing does not fall under the definition of entrapment. And courts recognize that oftentimes testers are obtaining evidence that can only be obtained through testing. We need to know if the discrimination is happening, and testing is often the only way to do this. So the evidence that they provide is indispensable in discovering whether discrimination has occurred. And courts have also held that all persons have the legal right to truthful information about housing, and this includes testers. So this means that testers actually, if they've received unlawful or untruthful information during their test, while we rarely see testers bring their own complaints, testers actually do have standing to file a fair housing complaint based off their experience. Even if they never intended to rent that unit in the first place, they've still been harmed by receiving that untruthful information. And as you can imagine, testing can be a very emotional experience. Whether or not someone actually intended to rent a unit or apply for a mortgage, if a tester knows that they're being treated differently because of their race or their national origin or any other characteristic than our white testers have been treated, that's still a harm. That is still, that's still an emotional experience, whether or not they ever intended to, seek that housing. So that was the crash course in testing. So I'm going to pause here to see if we have any questions before moving on to enforcement.
Yeah, so there is one question in the chat. One of our attendees is wondering, how has testing changed with the use of online applications?
Yeah, great question. Could go on and on about this. But I'll say there's pros and cons to a lot of, the more online aspects. One thing that we like, I'm also a test coordinator in addition to being a staff attorney. So one thing that we like is if something's happening online, an online application, then, turns into emails or something, we can have a lot more control as test coordinators if we're seeing what's happening, if we're seeing the information that our testers are providing. It's almost as if you're on the test with the tester, because, you can see what questions are being asked on an application. You can see, oh, if you don't answer this question, are you automatically rerouted or the application closes? So it is good information to have, but I would say the flip side of that, what's really frustrating is, I think this comes up the most in source of income cases where an application what we see a lot is applications that require you to put in either like workplace or, an income amount, and say someone has no income, or, they pay entirely with a subsidy. A lot of online applications don't even have a field, or, will automatically close at that point. So that's where testing isn't, going to be super useful. And in those cases, we might just reach out to the management company directly ourselves and indicate that this is, a fair housing. It could be a fair housing issue even before someone, submits an application or gets through one page of an application. Yeah, those are my thoughts.
Great, thank you. I think that's all the questions for that section. But thank you.
Great. I had another thought. If it comes back to me, I'll jump back. Okay, so enforcement. A great tool that we have in fair housing law is filing administrative complaints, and as an alternative or a precursor to a lawsuit. So now I'll get more into that enforcement. Oh, I remember what I was going to say about the online applications. It can be useful, say someone is able to get through an online application, and we're doing it, say, based off national origin or race, and we have identifiable names and aliases in the profiles. even if two people are able to submit an application or we don't typically do full application testing, but submit an inquiry, or, get through certain pages online, there's a lot of times a difference in who gets a response and what that response is. So then, someone not even receiving a response to an online inquiry can be seen as evidence, based off name or profile or what is submitted in those online inquiries. So sometimes the absence of a response is great evidence through testing as well. Okay, back to enforcement. So statute of limitations in fair housing cases. So an aggrieved party can file a lawsuit in federal court within 2 years of the alleged discriminatory act, or filing an administrative complaint with HUD or CRD within 1 year of the alleged discriminatory act. So we do have a shorter statute of limitations in admin complaints. Who can file a complaint? Who has standing to file a fair housing complaint? Anyone who believes they've been discriminated against in housing can file a fair housing complaint with the government. So this includes individuals, as I kind of touched upon with testing. It can be, a bona fide, someone who really experienced this discrimination in the course of their own life, or a tester could also file a complaint as an individual. Private fair housing groups such as us, fair housing advocates, we have standing to file a complaint. So that's, based off diversion of resources, harm to the community. Government agencies also have standing to file fair housing complaints and class complaints of people in the same situation. So the administrative agencies where we can file fair housing complaints at the federal level, of course, we have HUD, the Department of Housing and Urban Development, and HUD can investigate claims of discrimination based off federally protected classes. And then at the state level, we have California's Civil Rights Department, formerly DFEH, the Department of Fair Employment and Housing. I believe they changed their name about maybe a year or a year and a half ago now, so still can feel new to people. And CRD investigates claims of discrimination based off state protected classes, or CRD can also investigate based off federally protected classes, again, because of that analog between the Federal Fair Housing Act and California's Fair Employment and Housing Act. So some benefits of the administrative complaint process as opposed to a lawsuit. First and foremost, it's free to file a complaint, unlike lawsuits, which we know can be extremely expensive. No court or filing fees, attorney's fees, experts, because there's no attorney necessary. So the admin complaint process is designed for people without lawyers, theoretically. However, of course, a complainant can retain a lawyer or other representative if they want to. And we do, represent complainants in certain fair housing cases, but it's not a requirement. It is, designed for people without attorneys. So I'll just add on to that. That can be a good, tool to know about if this isn't a complaint that your organization would choose to represent on. It can still be really useful to give people the information about filing administrative complaints and let them know, it's free to file, here are the steps. And, it's another avenue they have when it can feel frustrating to have people tell you no. So an overview of the timeline for administrative complaints. The HUD complaint and the CRD complaint really mirror each other. So when there are differences, I will point those out, but otherwise, they're pretty similar. So both complaints you submit online on their portal. I'll get into each step more in the next slides, but there's online portals, or you can call and submit a complaint. I think online and calling are the two options. Then after submitting a complaint, the complaint gets sent to their intake departments, and you go through the intake process and perfect the complaint. There are multiple opportunities for settlement throughout the process. There is the respondent's response to the complaint, investigation, and ultimately a conclusion of the complaint. So we'll go more in depth. Submission for either HUD or CRD, you can draft and submit your complaint through their online portals. A lot of times, even if you file a complaint originally with HUD, they'll just send it to CRD, and it'll be referred to CRD anyways, even if you choose to file with HUD. And then the first step when you're submitting it is you'll choose a date for the intake interview. And on that date and time, you'll have a telephone interview with an intake coordinator whose job is just to determine whether HUD or CRD has jurisdiction. These are really, really bare bones. It's, again, designed for people without attorneys. So they're really just making sure that, is there an allegation of a fair housing complaint here, basically, and was it within the statute of limitations? That's really all they're looking for here. Then the intake counselor will, this is kind of a weird step. They, at both HUD and CRD, will draft their own revised copy of the complaint. Again, I think geared towards people who aren't represented. So if you are an attorney working on one of these cases, the intake submission probably won't be edited too much. They're really just trying to make sure they have the relevant facts and allegations in there. They'll send it to the complainant or the complainant's representative, if there is one, to review and suggest any edits, any additional facts or allegations that you think should be in there that the intake counselor might have missed. And then once you go back and forth on that, the final complaint is signed by the complainant, and this is referred to as being perfected. So important to note here, the complaint has to be perfected within the statute of limitations. So, scheduling the intake interview and then perfecting the complaint can be, honestly, 2-3 months, depending on how far out they're scheduling intake interviews. So if the date of last harm is approaching the statute of limitations, you would want to contact someone at HUD or CRD to let them know that you need to expedite the intake because this all needs to get done before that statute. Then once the complaint is perfected, once it's signed, it's sent to the respondents. So opportunities for settlement, both agencies want to settle these complaints. So HUD refers to this as conciliation, CRD's mediation, and these are a little different. So I'll go through the differences here. HUD doesn't have a formal mediation process, but the investigator that the complaint is then assigned to will try to get the parties to settle throughout the course of the investigation. So they'll be having those conversations, alongside the investigation conversations. CRD has a specific mediation process, which we've had, good outcomes from. And typically, if I'm considering whether to file something with HUD or CRD, I might lean towards CRD's mediation process is, a neutral third party who will encourage each side to mediate. And then if parties decline or are unable to reach settlement, the investigator can also, serve as that intermediary throughout the course of the investigation. If a case does settle, terms of the settlement may include tangible relief, such as moving into a unit, changing a policy, or rescinding a termination notice. Also, monetary compensation for economic and non-economic damages, including emotional distress, and of course, in issues of discrimination, of course, emotional distress is oftentimes a huge bulk of the monetary compensation. Also, injunctive relief, including training for housing providers, again, changes to policies, requirements that they affirmatively market units in certain ways or on certain websites. You can really get creative with the injunctive relief here. So after the complaint is sent to the respondents, the investigator will contact the complainant to discuss the respondent's response. One thing that is a little different or difficult in an administrative complaint is typically the investigator will not turn over the written copy of the response. They will convey, whatever the respondent said to the complainant or the complainant's representative only over a phone call. So, we always ask to get that in writing, but you don't always succeed. And then based off the respondent's response, complainant prepares a rebuttal brief, including any additional evidence and exhibits that haven't yet been included in the investigation, if any, and give this to the investigator as a rebuttal. Then the investigation will continue and the investigator will review the evidence and also talk to witnesses, any relevant parties that the respondents or complainants want interviewed. If this is a case about disability discrimination, often they will send, a medical records request to the complainant's healthcare provider, whoever verified the disability-related need. And this investigation should ideally be completed within 100 days, but if it's going to exceed that timeline, the complainant will receive what we call a 100-day letter from CRD or HUD, including an updated timeline. After the investigation and any attempts to mediate, a investigation closes with either a cause or a no cause recommendation. So with a no cause recommendation, if the investigator decides that they did not find evidence of discrimination. Another benefit of filing with CRD is that CRD sends complainants a 10-day letter before the case closure, letting them know that the investigation found no cause. So this allows complainants to either provide additional evidence or withdraw the complaint and potentially file a lawsuit before the respondents receive that no cause letter. HUD doesn't send any notice to either side. They just send that no cause determination at the same time and close the case. So, depending on if you want that leverage, that's something CRD offers. If the investigation does conclude with a cause finding of discrimination, then the case is referred to another mandatory mediation or a mandatory mediation. There's another opportunity to settle before the agency's legal department would then prosecute the case. And if they do not settle at mandatory mediation, HUD or CRD can file a lawsuit on the complainant's behalf. All right. And that is the overview of enforcement and administrative complaints. If there's any questions.
Yeah, I'll reiterate. If there's any questions, please throw them into the chat in the Q&A. If you could just kind of go into kind of the supplemental materials that we also provided, maybe a description of some of those might be helpful.
Yeah, definitely. So if you, I won't go back, but when we were talking about testing, I mentioned, a few cases in which courts have found that testers have standing and, that testing is a protected activity. You do have those cases to refer to. And then some examples, either, an example CRD complaint or a redacted rebuttal brief, just to see what the intake looks like, and just what to expect out of administrative complaints, what a rebuttal response would look like, and as well as the form CRD. If you mediate through their mediation program, they have a required form that they require both parties to use. They specifically require injunctive relief in any of their mediations. So, you can't just settle for monetary damages. And so there's an example of their mediation form. And if you settle through CRD, the mediator will be the one to actually draft that agreement. Once you decide on the terms, they fill it out. And there's really only 1 or 2 sections on there that can have any changes. They're pretty strict in what they like to keep in their form. So you have a copy of that as well.
Got it. Great. Well, I don't see any questions in the chat. If anyone wants to throw them in there quickly before we wrap up here. But thank you, Maria, again, even with a slight break in the middle.
I'm so
Thank you for coming.
sorry. I don't know what
Of
happened.
course. Thank you for coming back to us and sharing your expertise with us here. If you have any questions, the attendees in the chat, if you have any questions, please feel free to email Maria or I. I'll throw my email in the chat so that if anyone has any questions, I can forward them along. But with that, I think that wraps it up. Thank you so much.
I see a question. I think Creighton, how can we help? Did I see that?
I don't know if that was a question that got cut off.
I would always just say, always reach out to your local fair housing organizations and chit chat and see how you can all collaborate.
Definitely. Do you take like volunteer testers?
Yeah, great question. A lot of fair housing organizations have their testers be volunteers. I think before my time, Fancy's testers were volunteers, but we found that employee-employer relationship helps kind of like a two-way accountability and helps us keep a more ongoing relationship. Because of course, as testers, the longer they're testers with us, the stronger they get. And we do find the work so valuable. We want to pay people for their time. So we take volunteers in other aspects, but testing, we do have our testers be employees. But
Great. Yeah.
some of the best fair housing organizations, though, all of their testers are volunteers, and I applaud them. It's just not what works for us.
Got it. Yeah. No, and here at CWLC, we do work with pro bono attorneys on housing cases throughout the state. So if that's something you're interested, please shoot me an email. All right. Thank you very much.
Thanks, everyone.
Thank you for joining us for today's webinar. This webinar was hosted by the Legal Aid Association of California, also known as LAAC. We are the membership organization for California's civil legal aid nonprofits. Our job is to advocate in the legislature, in the courts, and with the State Bar of California on behalf of the community of nonprofits that serve low-income Californians. In addition to our online and in-person trainings, LAAC provides coordination and advocacy for increased funding to support organizations like yours. Thank you.